Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case, the Queen and Stevens, and this is a case out of Ontario that just came out December 18th. Now, this is not a case that sort of overturns the law or that defines important terms. Instead, this is a good example case because it takes certain law, in this case, law relating to antiques, and just applies it properly and well. So it's a good way to learn sort of how the law applies. Now, I'm working on a longer video. It's the case of the Queen and Lee, which is 311 paragraphs, I think. So I may get some shorter videos out in the meantime while I get that together and try to figure out how to make that one not a 6-hour epic. All right, so let's dive into this case here. So what we have is Kathy Chartier rented a 2019 Hyundai Elantra with a Quebec license plate from Enterprise Rent-A-Car in October 2019. She reported the car stolen to Enterprise on October 10th. The police became aware that the vehicle was stolen only on October 16th when it fled from Constable Nagrodsky and he made inquiries of the rental agency. So somehow there was some miscommunication, or she reports it to Enterprise on October 10th, but Enterprise doesn't pass that message along to the police. So on October 17th, this same vehicle, a dark Hyundai Elantra with the Quebec license plate, was reported to be driving erratically in the area of Gordon Street and Stone Road in Guelph. Officers Francone and McKean, who were in the area, heard the dispatch. They were also made aware that the vehicle was stolen. They then began checking known places for the vehicle. So probably places that they suspected a vehicle might turn up. At a local Days Inn, they saw a dark Hyundai Elantra with no front license plate. Vehicles licensed in Quebec do not have a front license plate. Same thing here in Alberta. Officer Francone knew the driver, Thomas Stevens, and he knew that he did not have a driver's license. The distance between where the Hyundai was observed driving erratically and the Days Inn motel was approximately 1 kilometer, so very small distance. The time between the 911 phone call reporting the erratic driving and the officer's observations of the vehicle at the Days Inn was approximately 7 minutes. Based on the foregoing, they formed the reasonable grounds to arrest Thomas Stevens for possession of a stolen vehicle. So even before they see the plate, they say, we're pretty sure that's our stolen car. And that seems to me to make sense. They've got a lot of information here. Search incident to the arrest of the vehicle. It would be incident to arrest of the individual, but they're going to search the vehicle just because he's sort of right close to it. Revealed a loaded handgun, approximately 130 grams of methamphetamine, and 50 grams of cocaine. Therefore, in addition to the stolen motor vehicle charge, Mr. Stevens was charged with a whole pile of stuff. Let's go through it. 1. Possession for the purpose of trafficking in cocaine, contrary to Section 5, Sub 2 of the Controlled Drugs and Substances Act. So, possession charges, there's two big, really common ones. Possession for the purpose of trafficking, which means you had this for the purpose of selling it. And then there's the lesser offense of you had this just for your own purpose or for a purpose we don't know. That's under 4 Sub 1 of the Controlled Drugs and Substances Act. But they also charge him with possession for the purpose of trafficking in meth. So again, they think he's dealing the cocaine and he's dealing the meth, which is probably not an unreasonable inference when we're looking at 130 grams and 50 grams. That's a lot for one person to go through. That would be one heck of a party. All right. Possession of a weapon for a dangerous purpose, contrary to Section 881 of the Criminal Code. Dangerous purpose here would, this one is not a big stretch, because if you think he's driving around dealing drugs, having a handgun for the purposes of facilitating your drug dealing is definitely a dangerous purpose. Now, possession of a firearm without being the holder of a license, contrary to Section 92 Sub 1. And 91 Sub 1. So the difference between those two is one is knowing you didn't have a license, one is just without a license. I'll get into that distinction in another video. It's not really the point here. Being a passenger in a motor vehicle while knowing there was a firearm in the vehicle, contrary to Section 94 of the Criminal Code. Possession of a loaded, prohibited firearm, contrary to Section 95(1)(a) of the Criminal Code. Careless transportation of a firearm, contrary to Section 86(1) of the Criminal Code. But not transportation contrary to regulations. We'll see that that's actually a bit of an issue here. Breach of probation ×2 for keeping the peace contrary to Section 733 of the Criminal Code. So he's on probation. Keep the peace and be of good behavior is a mandatory condition there. And basically it means don't commit any other crimes. The ×2 means that he's almost certainly on 2 separate probation orders, and also breach of a weapons prohibition by possessing a firearm contrary to section 117.01 sub 1 of the criminal code. So let's count the gun control restrictions on this individual. 2 for the breach of probation. And, you know, because those probation conditions would prevent him from having a firearm without a license. And then all of these licensing provisions, and also not just is he unlicensed, not just is he unlicensed and on probation, but he's also banned from having guns. So clearly he's not going to have, oh, right, he has a gun. Anyway, that's just sort of underlies the assumptions of a lot of our laws here. But regardless, those things will enable the court to add some additional punishment. Mr. Stevens did not testify on his behalf, nor was any other defense evidence called. Therefore, as with most cases where the salient legal finding relates to the issue of possession, this court must determine, based on the circumstantial evidence and the Supreme Court's direction in Villa-Roman, whether the Crown has proven all the essential elements of the offenses, and the only available inference is that of Mr. Stevens' guilt. However, before turning to that assessment, at the conclusion of the Crown's case, the defense requested a directed verdict on the following charges: Section 86.1, Section 91, Section 92, Section 94, 95, and 117.01 sub 1 of the Criminal Code. So the defense is asking for those charges to be thrown out. The defense is saying, listen, and this is a high standard. Basically, the way you get this directed verdict is if there's no possible way for the judge to convict, either because there's no evidence on that point, or because the law says that what they did isn't an offense. So it's a tough standard, because if there is some evidence, then it's going to go past the directed verdict stage, and the judge is going to have to do some consideration of it. So the Crown really does not like a directed verdict. It's kind of sometimes embarrassing, although sometimes the Crowns themselves will recognize that they have a problem. I've had trials where the Crown at the end of it says, listen, Your Honor, we haven't proven the following charges. We ask for a directed verdict against us. Please throw out these charges. And that is entirely proper. You know, if the Crown recognizes that they don't have a conviction on that, it's entirely proper for them to do that. And so that's another way a directed verdict can happen, is the Crown can invite it. But this case, the defense is saying they can't possibly make these out. Please throw those charges out without considering them any further. All right, so the court granted that directed verdict motion and noted with more detailed reasons to follow. Now, they didn't grant it entirely, they granted it in part. So let's have a look at their reasoning. So here on the directed verdict, the handgun located in the vehicle was a .44 Smith & Wesson Russian. The provincial Crown agreed that this handgun had been shipped to London, Ontario on August 31st, 1889. So somehow they've got records dating back to 1889 on this particular gun. But the court goes on to say the obvious implication and the only reasonable conclusion to be drawn is that this handgun was manufactured sometime prior to August 31st, 1889. So, and that makes sense. I mean, either somebody out there has a time machine and is messing with the court by sending this gun back and forward in time, or else this gun is older than 1889, which raises some issues, because when we've got a gun that's that old, is this gun an antique is going to be a big issue here. So section 84.1 of the Criminal Code, read in conjunction with the regulations prescribing antique firearms, hereinafter regulations, deems a handgun manufactured prior to 1898 capable of discharging center fire cartridges to be an antique firearm. Now, let's stop right there. I'm going to sort of pull up the law here on this, because it gets a little interesting. So first, we see antique firearm. Antique firearm means any firearm manufactured before 1898 that was not designed to discharge rimfire or center fire ammunition, and that has not been redesigned to discharge such ammunition. So it does not qualify as an antique firearm under subsection A. So that doesn't help us. But B says any firearm that is prescribed to be an antique firearm. All right, so now we need to know what is prescribed to be an antique firearm. And so I'm going to have to adjust my screen here a little bit just so that I can... Oh, wait, this will work. All right, so this is the regulations prescribing antique firearms. So this tells us what else is defined as an antique firearm. All right, so the firearms listed are antique firearms for the purposes of paragraph B of the definition. And black powder reproductions, that doesn't apply. There's no indication that this is a black powder firearm. However, if we go on, handguns. Handgun manufactured before 1898 that is capable of discharging only rimfire cartridges. That's not going to help. Or 7, this is where the action is. I'll scroll down so you can see it. A handgun manufactured before 1898 that is capable of discharging center fire cartridges other than a handgun designed or adapted to discharge 32 short Colt, 32 long Colt, 32 Smith & Wesson, 32 Smith & Wesson long, 32-20 Winchester, 38 Smith & Wesson, 38 short Colt, 38 long Colt, 38-40 Winchester, 44-40 Winchester, or 45 Colt. All right, so going back to our case, we see 44 Smith & Wesson Russian. All right, does not appear to be on our list, which means good to go. So the court's going to apply this here. Excluded from this, read in conjunction with the regulations prescribing antique firearms. So they're saying, reading them together, deems a handgun manufactured prior to 1898 capable of discharging center fire cartridges to be an antique firearm. Excluded from this deeming provision is a specific list of firearms which were adapted or designed to discharge certain types of ammunition. The 44 Smith & Wesson Russian is not on that list, and therefore I find it to be an antique firearm. This deeming provision is of significance to the accused because under section 84 sub 3 of the Criminal Code, an antique firearm is not considered to be a firearm pursuant to sections 91 to 95, 99 to 101, 103, and 107, and section 117.03. As surprising as this is to the court, this is a relatively straightforward analysis. Since the 44 Smith & Wesson Russian is not considered to be a firearm under section 91, 92, 94, and 95, Mr. Stevens cannot be convicted of those offenses. Now, this is a place where it's worth stopping and sort of noting here that quite commonly people say, listen, an antique firearm is not considered a firearm unless you use it in a crime. But that's not actually how the law works. It's not that you use it in a crime and then it's suddenly outside of a firearm, because what we see here is Mr. Stevens, the allegation is that he's involved in a criminal act. He's involved in the act of drug trafficking is the allegation at this stage. Now, because this is a directed verdict, the court basically has to treat those allegations and the evidence on that as if it was, they can't say, oh, well, we're going to evaluate that because directed verdict. It's a very sort of early kind of test. And so you essentially have to give the Crown's case all the credit that it can be given. But this is just that it's exempted entirely from those sections. So he can't be convicted even though the circumstances are sketchy as heck. So... but there's other sections that it's not exempted from, which are often themselves criminal acts. For instance, pointing a firearm at somebody is not an exempted section. All right, so in coming to this conclusion, I did take into consideration the definition of prohibited firearm under section 84.1 of the Criminal Code. A prohibited firearm is a handgun with a barrel length less than 105 millimeters. The Smith & Wesson's barrel length appears to have been modified to 70 millimeters. So is this a sawed-off handgun? I don't know. However, the regulations prescribe the 44 Smith & Wesson not to be a firearm for the sections 91, 92, 94, and 95. Therefore, although somewhat tautological, it cannot be a prohibited firearm for the purposes of section 84.1, as it is not a firearm pursuant to sections 91, 92, 94, or 95. So this, again, is why, for instance, an airsoft gun, like this one, which, otherwise would be a prohibited firearm because of the whole aspect of this thing having an automatic fire mode. is not illegal to own because it's exempted from those sections. So I can legally own this, which is good. I don't like the RCMP coming to my door, but this case very clearly illustrates that. I'm strengthened in my reasoning by the regulations themselves. Section 7, which deals specifically with antique handguns capable of discharging centerfire cartridges, refers explicitly to adaptations which would take it out of the deeming provision, namely those relating to the type of bullets the handgun is capable of firing. Nothing is mentioned about adapting the barrel. Hence, since they refer to one adaptation and not the other, I find that adapting the barrel length does not take the 44 Smith & Wesson outside of the deeming provision, and despite the barrel length adaptation, this handgun still falls within the definition of an antique firearm. Now, if he did saw off the barrel, I mean, that's a tragic thing to do to an antique firearm, but this antique firearm has an even more tragic fate, as we'll see as we go. All right, therefore, although the handgun was operational, loaded, able to cause serious bodily harm or death to a person, and it meets the definition of a firearm in Section 2 of the Code, I find that the 44 Smith & Wesson found in the motor vehicle is not a firearm for the purposes of Sections 91, 92, 94, and 95 as a result of the operation of Section 84.3. I did not grant the directed verdict in relation to the Section 86.1, that's the careless transport charge, and Section 117.01, that's the possession of a firearm contrary to a prohibition order. Section 84 sub 3 specifically lists those offenses where a weapon meeting the definition of a firearm in Section 2 of the Criminal Code is taken outside of the ambit of that definition. Therefore, since Sections 86.1 and 117.01 sub 1 are not mentioned in 84 sub 3, the 44 Smith & Wesson Russian, which otherwise meets the definition of firearm in Section 2, is to be considered a firearm for those sections not specifically listed in 84 sub 3. And this is really, well-trod law. This is absolutely the way the law works. So finally, the exception under 84 3.1, as raised by counsel, does not apply. That exception relates to contravention of storage regulations, Section 86.2, and not careless use. So let's have a real quick look at what that means here. I'm just going to find that little section here. So exception for antique firearms 3.1. Notwithstanding Section 3, an antique firearm is a firearm for the purposes of regulations made under paragraph 117H of the Firearms Act and subsection 86 sub 2 of this act. So what that means is that antique firearms, unlike, an airsoft gun, must be stored in keeping with the firearms storage regulations, whichever class applies to it. If you have an antique prohibited firearm, then it would have to be stored per prohibited firearms, or transported, or the like. So that's what the judge is referring to here. So the judge has struck those charges. They're just gone. He's acquitted on those charges, and he gets to walk. Now, there's a big analysis here in terms of the possession issues, because there's a big question of whether or not the judge is going to find that he possesses the stuff in the car. That's less interesting here, so I'm going to just skip over it towards the end here. And so they say, finally, even if I give credence to the defense argument that a third party left approximately 170 grams of meth and cocaine in the footwell of the vehicle, which Mr. Stevens was in possession of, they would not have done so without the knowledge of Mr. Stevens, especially since the placement in the driver's footwell could have posed a hazard to him. The same reasoning applies to the handgun in the passenger seat. So they do find him guilty of both charges of possession for the purpose of trafficking, as well as the other issues there. So remaining offenses on the issue of possession of a weapon for purposes dangerous. They say the public peace refers to the normal peaceful state of society. The possession of cocaine and a loaded cocked handgun concealed in a car to maintain control over a controlled substance is antithetical to the whole concept of public peace. Thus, I conclude beyond a reasonable doubt that the cocked handgun gun was in Mr. Watson's possession, because this is quoting from a different case, for a purpose dangerous to the public peace. Therefore, I find him guilty of that charge. Given the findings above, both in relation to the handgun and the narcotics, and the admission that the probation and weapons prohibition orders were valid, I find Mr. Stevens guilty of the remaining charges: 2 breaches of keep the peace, a breach of the weapons prohibition, possession of the stolen motor vehicle, and careless use of a firearm. All right, so we see the proper analysis of the antique firearm issue, which allows this particular accused to walk on certain charges, and he's walking on them because he's not guilty. This is not like a technicality. This is the law properly applied to his specific circumstances. People often say, oh, we got off on a technicality, and usually a technicality falls into a few broad categories. Category 1, didn't do the crime, which is what we see here. He didn't do those specific offenses. Category number 2 is somebody's rights were violated. And that, so evidence gets excluded under the Charter, but that's the proper operation of the law as well. I mean, the Charter of Rights is important. It's important that we have rights and freedoms, including rights and freedoms against certain police activities. So that, people call it, oh, we got off on a technicality, but really, that's how the law is supposed to work. And the third one is often the Crown makes some mistake in terms of proof, or makes some mistake in terms of charging. And so, again, that's how the law is supposed to work. It's not like, people are sort of getting away with things on, for sort of BS reasons or something like that. Now, the other thing I'll note here, we went through this big long list of charges, and I noted that they didn't charge him with transportation of a firearm contrary to section 86 sub 2 of the criminal code, which would have been a violation of the regulations. Had he been charged with that, I think that they almost certainly could have gotten a conviction, because as we just sort of determined, antique firearms do have to be transported in keeping with the regulations. And so they could have gotten that additional charge. Now, that wouldn't have gotten them anything further. The other thing I'll note here is in terms of the likely sentence here, I don't know all of the circumstances here, but with these sorts of levels of drug trafficking and all of that, we're looking at years rather than months in terms of the sentence. The other aspect of the sentence, and this of course is going to be sad for many of us, is that this antique firearm is going to be chopped up and destroyed, which is unfortunate because they're not making more antique firearms. That's a closed and shrinking pool. So it's always sad when I hear one of those getting sent to the chop saw and the smelter. It's I like nice guns, and yeah, it's unfortunate. Anyway, thank you for watching. Please like this video. Please share it with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters, D. Mo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft, as well as those are all at the $50 level. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt, as well as the $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope I've armed you with knowledge.